Welcome to Bloomberg Law on Demand. I'm Pacchia. Google's plan to digitize the world's books, making them available to users of the search engine, suffered a setback in federal court last week. Joining me now to discuss, we have New York Law School professor James Grimmelmann. James, thanks so much for coming in. Welcome.
Great to be here. Thanks.
So, you are one of the leading thinkers and commentators on this issue. You've called the deal that Google struck a once-in-a-lifetime settlement, and you've said that everyone who writes or reads has a reason to care about this settlement. Why is Google's books and now the rejected settlement such a big deal? Why has it been in the news flow for the last 4 or 5 days?
So Google's plan was to create basically a new Library of Alexandria, an online digital library that would ultimately have every book ever written in it. And the settlement was a very clever, and ultimately probably too clever, way of getting around some of the copyright law obstacles in the way of that. Mm-hmm.
It sounds logistically like quite a challenge. I mean, they've been working on this since 1998, when one of Google's founders basically had the idea to physically scan all the world's books and put them in a large database. Logistically, how does this work? I mean, it just seems like a monumental task.
So for the last half-decade or so, they've been partnering with research libraries around the world at major universities and some national ones to go in and basically, one by one, pull all of the books off the shelf, and then they put them in dedicated scanning machines and take high-resolution photos of each page, and then they can look it over, stitch the pictures together, and create a full digital image of each book. Mm-hmm. Repeat 30 million times.
Right, but they ran into legal problems along the way. What happened?
So originally they started by scanning just public domain books, books for which the copyrights expired, and of course, nobody can object to that. But then they started in 2004 and 2005 in the US to scan some books that are under copyright. And their argument there has always been that we're just making a search engine right now. It's like on the web. Google goes and looks at web pages, and the web pages are copyrighted, but Google needs to make a copy in order to know what words are in it so it can tell searchers what pages have those words. Same thing with books.
Some people have raised an issue, and I'm not sure if this is necessarily a problem, but they're saying that in creating this search database, they're essentially monopolizing some database or some area of research, and at the same time, they are put in a position where they could potentially manipulate the search results. Are there anything to those claims?
So I've never been really convinced by the monopoly arguments there, because in that respect, anybody willing to take the legal risk that Google did could have gone out, scanned all these in-copyright books, and made their own search engine. On the other hand, there's the manipulation concern that people fear that Google elevates some websites and demotes others, and it picks winners and losers. And when it comes to the world's literature, that has a certain kind of resonance, because the idea of banning books or pushing certain books on people, it raises cultural fears.
Right. We've always spoken about the literary canon. Is Google out there trying to reinvent the canon?
I don't think they have that agenda. They see themselves just as technocrats.
But inevitably, they're going to be doing it by arranging search results for, say, if you have to put out there a search term for the best book on the colonization of Africa in the 17th century, there are a number of books on that topic, and figuring out what's at the top of the chain, how do you do it?
Yeah, all search always involves picking winners and losers in the rankings. Mm-hmm. And this project with the books in particular has been a bit controversial because they have to pick editions of books. So there are, I don't know how many hundreds of editions, how many thousands of editions of Shakespeare out there. Well, Google has to pick which copy to show you. And they've actually been criticized over some aspects of this, because in the 19th century, there were a lot of fairly junk, cheap editions. And because of the fact that they're in the public domain, those are often the ones that come to the top on Google searches.
Mm-hmm. So we have this settlement that came out last week, or a decision on the settlement that basically came out last week rejecting it. What was in, the judge was Denny Chin in the Southern District of New York. What was in the ruling? What did it say?
So I should give you some context on the settlement, too, which was basically Google got sued by authors and publishers objecting to the fact that it was scanning all the books, making a search engine out of them. And somewhere along the way, they started negotiating, can we settle this case rather than going to trial and having expensive litigation. And the negotiations took a kind of interesting left turn. Mm-hmm. And when they came out of the closed rooms, they said, you know what? We settled the scanning and searching part, but we're also going to create a gigantic bookstore. Google has these scans. It would be a shame not to do something with them.
Right.
Why don't we let Google sell copies of them?
That's an interesting development.
And then Google would split the revenues with the authors and publishers.
Now, there have been two tracks of analysis of Denny Chin's decision. A lot of people have focused on the antitrust issues, but we were speaking before, there's a lot of copyright issues, implicit and explicitly. What jumps out at you on the copyright side? What should people be paying attention to there?
So the way to think about this is opt-in versus opt-out. Mm-hmm. Traditionally in copyright, you put pen to paper, you get a copyright in the book that you write or the cartoon that you draw. And then if anybody else wants to make a use of it, under many circumstances they need to ask your permission. Not always. Critics can quote parts for reviews and other fair uses. But if somebody wants to publish a complete edition of your novel, they need your permission. So you have to opt in to letting them do that. Mm-hmm. The class action settlement works the way that class action settlements usually do, which is opt out. If you don't write back to the court by the designated notice deadline, then you're presumed to consent to the terms, and congratulations, you've just consented to Google selling your book online. Mm-hmm. So that flips the default. Suddenly you have to opt out, and just sitting back and doing nothing means you've actually given them permission.
And what's problematic about that?
Well, for one thing, it rubs a lot of authors and publishers the wrong way, because this is not how they've been told the system works, and they're pretty upset by that. So they see it as violating policy of copyright.
Mm-hmm. I guess change comes hard to the publishing industry.
Yeah, I mean, they're adapting now to online publishing, and I think some of that discomfort was part of the initial reluctance of the settlement. I guess the other thing that's bothered maybe more academics about this is the fact that we know there are lots of authors and publishers out there who can't be found. These are so-called orphan work owners.
Right, we want to talk about that. What are orphan work owners, and what should their concerns be?
So an orphan work is a book that's in copyright. Mm-hmm. So the owner still has a copyright, but you don't know who to ask and you can't find them. So if you want to print a new edition of a book, okay, great, I'll just find the owner and get their permission. And you start looking, and you find out that it's somebody who died 30 years ago, and then their wife and only heir died, and we don't know where the kids are. Or it's a publisher that got bought out and merged a few times, and it's all just a mystery. You can't get permission. So the book just languishes there. Nobody's willing to publish it because of the legal risk, but it's also not making money for the copyright owner. So it's a kind of breakdown in the copyright system.
So where are we now? We have a rejected settlement. Are we going right back into the courtroom, and is this going to turn into a litigation dogfight, or do you expect another settlement to come out of the negotiating room?
So the parties could appeal this and ask the appeals court to reverse the district judge. Mm-hmm. Another possibility is that it could negotiate a new settlement, something less ambitious, and he kind of hinted that he might be okay with a settlement that went to an opt-in basis rather than an opt-out. Or they could go back and litigate the underlying lawsuit about Google's search engine and have a big knockdown, drag-out copyright fight.
Mm-hmm. Are we going to see legislation coming out of Congress on this?
So that's always a possibility. Part of this has happened because Congress didn't act. There were bills to start doing something about the orphan works problem in the last few sessions of Congress that would have let people make new editions of books and other works if you'd done a diligent search for the owner. And twice that stalled out in Congress. So some people, including myself, have seen the settlement as a kind of attempt to do the same thing through the courts instead of through Congress. And Judge Chin pretty explicitly said in his opinion, no, you can't do this here. If you wanted to fix the orphan works mess, this is a job for Congress. So it's quite possible that Google, with all these scans and these books it can't do anything with yet, will want to go back to Congress and make a renewed push on orphan works legislation.
Real quick, in the time remaining, do you see this episode as potentially opening the door for more antitrust litigation coming Google's way?
So it's definitely a mark against Google, but this is something that was blocked before it could happen. So I don't think it adds to Google's power. If anything, it reduces it a bit because Google can't make very many uses of these books without the court's blessing. Mm-hmm. So in some sense, Google has been knocked down a peg, which means on the antitrust side, there's a little bit less to worry about.
Interesting stuff, Professor. We'll have to see how it goes. Unfortunately, we're out of time, but I want to thank you for coming in. That's Professor James Grimmelmann. He is a professor at New York Law School. If you'd like to learn more about the issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching.